The following program is for informational and educational purposes only and is not to be considered legal advice. Fraudsters Radio was created to expose the many scams and frauds that have so infected society today. Scammers, fraudsters, and rip-off artists abound, whether it's scamming homeowners with bogus foreclosure relief services, dating fraud, incompetent lawyers, or consumer rip-offs. It's high time the public has a voice. If you work in a profession that deals with fraud, or if you believe you were or are a victim of fraud, you now have a radio listening public that wants to hear from you. Please feel free to message us through our Fraudsters Radio Facebook page, and we may have you on the show as a guest. If you'd like to call in for today's show, the number is 646-668-8512.
And welcome to the show. This is your co-host, Laurie Z. I'm a consumer advocate, and I've got with me on the line my co-host, Storm Bradford. Welcome, Storm. It's good. We're on show number 2 today. How are you doing?
I'm fine, Laurie. How are you doing?
I'm doing okay. I'm looking forward to talking about fraud. You know, it's kind of our favorite subject here. You're the owner of Mortgage Fraud Examiner, so you are a litigation consultant. And I'm basically a consumer advocate and a credit consultant. And what we're doing is we're going to be talking about different topics. And why don't you start today with one of our favorite topics?
Well, I guess more or less it's just dovetailing with last week's show where we were exposing some of the so-called foreclosure defense attorneys, a.k.a. pretender defenders, on how the vast majority of them are just ripping off homeowners by doing nothing more than just taking their money and stalling the foreclosure. But the outcome is always the same. The homeowner ends up losing their home.
Right. Now, off air, you and I had talked about maybe coming up with some type of a list that people could go to an attorney with and ask questions, because to me there was nothing more stunning than receiving calls saying, you know, they'd say, hey, I've hired a lawyer, and I go, well, how many cases did your lawyer win? And people are like, what? And I'm going, yeah, how many cases did your lawyer win? So maybe why don't you talk a little bit about questions that people should ask when they're going to hire an attorney, and how can they check them out? Well,
I don't care what kind of case that someone may have, whether it be criminal or civil. They need the most important question when they meet with an attorney, because actually you got to remember they're interviewing him for a job, and they have to treat it that way. They're going to be paying him. They're interviewing for this job, and first and foremost, they need to figure out or ask this attorney, whatever the subject area is. Let's say someone was charged with a DUI, okay? First question out of that person's mouth is, have you ever litigated a defendant in a DUI case? If the answer is no, grab your purse, go out the door. If he says, yes, I have, second question is, how many have you won? And if the answer is none, grab your purse and go out the door, because there's plenty of criminal defense attorneys that hardly ever lose a DUI case. Same thing with the civil case. If it's a foreclosure, question is, how many of these cases have you done? If the answer is none, you walk away. Second, if he says, well, I've done several, well, how many have you won? Okay? A win is not a stall. A win is when the homeowner either gets financial remuneration from the bank or free title to their home. It is not stalling. There's a lot of attorneys out there that go in and they say, well, I won this case last week. Well, in actuality, they only stalled it. It's not that they won, it's that the bank lost because they didn't have the note when they filed the complaint. Like in Florida, for an example, you have to have the note before you file the complaint. Well, if they didn't have the note, the court says, hey, sorry, bank, you didn't play by the rules, so I'm going to go ahead and dismiss your case. If you want to foreclose on this person, you better come back here next time with the proper paperwork. So that's how it works. So you got to ask the hard questions, and some of the questions in the foreclosure scenario that they can ask is that they can say, look, can you show me 3 of your last foreclosure defenses, your answers and grounds of defense? And if those answers and grounds of defense are basically the same, you're going to know what type of a lawyer you have. You have a copycat lawyer that all he does is use the same defenses just over and over again. We see this all the time.
Let me ask you a question. Is there a way before someone goes for an appointment or calls an attorney, can they go into the court records online, type in the attorney's name, and then try to determine from that if the attorney has actually won cases or lost cases?
Yeah, and it depends on the state, and sometimes it depends on the county in the state. Some counties and states, you can go online. You can search the records, you can put the attorney's name in, and all the cases that he handles piles up. About 3 or 4 years ago, somebody called me, and they said, look, there's this one attorney in Florida who claims to have saved thousands of homeowners their homes. He told me the lawyer's name. I said, well, that's a lie because I know what his arguments are. Trust me, he's never won a case. And he goes, well, is there a way to prove that? And I said, well, which county is he in? And at the time, he told me what the county was. And I said, well, look, we'll go online and see if, in fact, what this guy's done and what he hasn't done, if those records are available. Well, they happen to be available. That was, I remember, it was in midsummer of that year. I think it was in, late June around that time. And that attorney had already lost over a dozen homes already that year to foreclosure.
Okay, and these people say they win. They say they win, but like you're saying, it's just a stall block, meaning it's going to happen. It's going to continue on.
Yeah, they're just going to come back. A bank doesn't even have to appeal that decision that where the judge said that I'm dismissing the case. He just refiles it. Another way for homeowners to know, any attorney that's arguing standing, assignment, produce the note, MERS, securitization, didn't get in the trust in time, chain of title, robo-signing, those arguments always fail. So if they're making those arguments, that's another key that guy probably doesn't understand. Well, he doesn't understand what he's doing. He's always doing is stalling.
So what they're doing is they're using those arguments to stall it out, but at the same time they're billing the homeowner their monthly fee in most cases.
Oh, absolutely. Well, I think as we spoke last week, you were there when one attorney told us that he charged the homeowners $3,500 up front and around $1,000 a month. And I asked him, I said, $1,000 a month for how long? And he said, I don't know, a year, 2 years, 3 years. And and then I said, well, what's the outcome? And he had finally admitted that he had never won a case, and which most of them, if you ask the right questions, will show that they have.
So basically, what's happening is, they're billing the client. The homeowner is thinking, hey, I've got a chance of winning. But I think the key word is foreclosure defense, because nowhere in foreclosure defense does it say foreclosure offense, or that we're going to counterclaim or do something, to put that attorney should be on the offensive. That's pretty much your premise. If there's something wrong, they should be on the offensive, but instead, no, because, I called a lot of attorneys, and they just don't want to litigate. They seem to collect the money. They earn a tremendous amount of money doing a monthly retainer, and yet they may only file pleadings or documents a couple times a year.
Well, I know, for example, there's one lawyer in Florida. His name is Neil Garfield, and he was teaching a course which he doesn't do anymore because everybody found that it was nonsense. But in one of his booklets, he said, I think it was on the 5th page of the booklet, he said, the majority of attorneys that took my classes in foreclosure defense averaged making $70,000 a year. All of those attorneys are now millionaires.
Mm-hmm. Unreal. And I have looked up actually Neil Garfield, and I think this is probably a year or two old, but basically it says he was publicly reprimanded following a June 9th court order. He was admitted to practice in 1977. In at least 4 instances, Garfield accepted money to represent clients and failed to follow through. In one case, Garfield did not perform the work and when asked for a refund, denied knowing the client. In other cases, he failed to communicate, charged excessive fees, and failed to return refunds upon request, and failed to timely respond to bar inquiries. And then it gives a case number. I mean, this says it's from the Florida Supreme Court. So I look at this list I'm holding has a lot of attorneys on here, and that's another concern is, why is people are not complaining to the bar? Or they're complaining and nothing's happening. I don't know, but I have a list, with dozens of attorneys' names for things that they did that they got in trouble or publicly reprimanded, and yet they pretty much get to go back to court, most of them. Some might get disbarred or suspended. Most of them get their jobs back.
Well, most homeowners in a foreclosure situation, they get inoculated by the attorney up front. And what I mean by that is the attorney tells them, look, you need to understand something. These courts are corrupt. The judges are in the bank's pockets, yada, yada, yada. And so already now the homeowner's looking at saying, oh, I'm not going to get a fair shake in court. So what happens? They go to court. The lawyer makes a bunch of stupid, ridiculous arguments that the courts have shot down all over the country hundreds of times, and they lose. And after they lose, the homeowner says, well, I lost my home. Yeah, I told you up front, you can't trust these judges. They're just crooked. So that's the reason why a vast majority of these homeowners never file a bar complaint, because they believe the lies and the rhetoric being told to them by these stall attorneys.
Right. And the fact this thing on Neil Garfield is it's saying, he failed to communicate, charged excessive fees, and failed to return refunds upon request. And so, I have friends that have been in this type of situation too, where attorneys they don't respond. I mean, to me, timely is 24 hours. I think that's timely. In Florida, maybe a week is timely. A week is reasonable. But I think when you get past a week and you're calling and emailing and, maybe texting your attorney and they're failing to respond, now you've paid them a retainer or you've paid them money and they're failing to respond. Is it at that point that you should terminate the relationship with that attorney and go back to the bar and file a complaint? And do you have any chance of even getting your money back?
Well, it depends. I mean, obviously if he was on vacation or something like that, he'd have an excuse. But if most bar ethics attorneys will tell you that it's an ethics violation for an attorney not to respond to you when you send in requests for information and you want to speak with the attorney. Matter of fact, there's a lot of attorneys, that's where they make their money, and that's talking to people on the phone. I had one person call me to tell me in a case, and it had nothing to do with foreclosure. It was a different type of case. And he said, I got a bill from my attorney for $6,000. And I said, yeah, what's he done for you? And he said, nothing. I said, what do you mean nothing? I said, you got the bill. What's it say on the bill? And never a motion filed, never a hearing, never been to court or anything. And what the $6,000 bill was for phone calls. The guy was $400 an hour, and he charged in 10-minute increments per minute. And all of the $6,000, it was $5,000 to $6,000. It wasn't quite $6,000. I think it was $5,000 and change, but close to $6,000. And had not done anything other than speak to this individual on the phone. And the person was someone that needed to be babysat and their handheld, so he's constantly calling this guy. And a lot of the calls, though, was, hey, what are you doing? So I've seen this quite a few times.
Sad. Well, we got a lot more to talk about. I do want to go to a quick commercial break. Stay with us, and if you want to call in live, our number is 646-668-8512. So call us if you have a question. Hang on, we're going to break.
Have your house payments skyrocketed under an adjustable rate mortgage? Have you been laid off or had your hours cut? Are balloon payments coming due? You need help from mortgage fraud examiners. To stop the housing crisis, Congress and the White House are pinning their hopes on homeowners renegotiating their mortgages. The trouble is, the banks are saying no 80% of the time. Mortgage fraud examiners can help you get the leverage you need to turn things around. They estimate that up to 85% of all mortgages are legally deficient. Mortgage fraud examiners can perform a mortgage transaction analysis and an appraisal to find legal deficits in your mortgage. It's like CSI for your home loan. Banks and lenders suddenly start cooperating when faced with a lawsuit for violating lending laws or appraisal fraud. Find out how mortgage fraud examiners can help you. Visit Mortgage Fraud Examiners. Call 844-920-7200. That's 844-920-7200.
We are back on Fraudsters Radio Show. I'm Laurie Z with Storm Bradford. We've been talking about all of the things that happen with the attorneys, and so I wanted to share one of my stories with you because I know you know who it is. But I had a friend that hired an attorney on a foreclosure. You actually met him in person. He was supposed to, be working with you with the mortgage fraud exam. And I know a couple of people that actually hired this attorney that said this was he was going to do. Didn't know in advance, my mistake for due diligence. I usually check people out. But apparently he had already been in trouble with the bar once before, back I think in 2008. So this now happens probably in about 2000 and I'm going to guess 12 or 13, somewhere around there when two people hired him. Big problem was he didn't end up using any of your exams. He didn't end up responding to these two particular clients. So one eventually got rid of him, and the other one called me a few years ago asking me about him, and apparently he was basically begging the client's job. He ended up, here's what happened. I'm going to tell you what happened to him. He was involved in a conflict of interest after representing a couple who purchased a house. When one homeowners moved out, he moved in, having developed a personal relationship with the woman. They subsequently married. The home suffered flood damage a couple of years later, and women retained him to represent her on the insurance claim. So he did receive there's public reprimands against these people, and there's so many of them on these lists. Is there what's in the Kool-Aid? Is there a lack of common sense? Because attorneys are fiduciaries, and they're supposed to be held to a higher standard. Yet I hear stories of attorneys that spend their clients' escrow money. And then what can that person do? So you go to the bar and you complain. How do you get your money back?
Well, yeah, some of these bar associations have funds that if the clients get ripped off, they can go to that fund and get some money. If they don't, and they've really been tattooed by some lawyer, they can sue them for malpractice or disgorgement of fees. So there are things that homeowners or any type of client can use. I'll give you another example just from another area of law. I know an attorney who all he does is DUI cases, DUI defense. He's at a resort, and so he gets, lots and lots and lots of DUIs. And he probably averages 4 or 5 DUIs a day. Last time I talked to this individual, he had not been to trial in 20 years. He pleads every DUI client guilty. Has him plead guilty, just like the foreclosure, these so-called foreclosure defense stall attorneys do, scares them to death, tells them, look, the law says you can do up to a year in jail and or a $2,500 fine. So I've cut a deal with the prosecutor. You're just going to do the day or the night that you spent in jail. There's going to be a $500 fine, and I'll get you a work relief driver's permit. This is what this guy does. A lot of attorneys, that's all they do is just plead people guilty. They don't even blow the dust off of a law book. That's what they do for a living. In the trade, they're called dump trucks. It's bleed them and plead them. So it's just not, it's all over all types of different industries. So it's like anything else. There, in any type of industry, there's competent people, there's incompetent people. And some of them are just in it for the money. So, it's
all right. Well, let me ask you one more question, and then I know Bob is waiting for us. Why is it that attorneys can have? I don't know how many times they can be sanctioned, but when you read on on the court records online or on the example down here at the Hillsborough County Bar Association, and it says this attorney has been sanctioned in this year and this year. How many chances do they get when some of them have committed such serious offenses? Is there a certain amount of things that they have to do? Because a lot of times what I find is people do call and complain, but if the bar, which I don't know, maybe they protect their own, bar doesn't find anything wrong with it, then it's still not listed as a complaint unless their grievance committee determines that. Yeah.
Well, that's kind of a fallacy in a way that the bar protects their own. You got to remember that when they disbar an attorney, they're taking his livelihood away from him. So it really has to be some egregious problems before they'll go that far and do that. If it's something that's relatively minor, it's a public reprimand. Sometimes it's a suspension for a period of time. But to actually take away somebody's living, it has to be really egregious. Now, having said that, there was an attorney, one of Neil Garfield's acolytes, if you will, that I believe it's up in Minnesota, and he had been sanctioned over $300,000 by the courts in Minnesota, coming in, making these same stupid arguments over and over again. And then finally, the Supreme Court of Minnesota, they just had enough, and they said, look, they filed a referral to the bar and said, look, you got to get rid of this guy. I mean, this guy's just harming the hell out of homeowners. So they finally disbarred him.
Yeah. Now, I want to introduce, we have consumer advocate Bob Hurt on the line, and Bob and I have also done previous shows together. Bob, we're talking about the pretender defenders and the rip-off artists right now in foreclosure world. But can you talk a little bit, because I know you write your blog, on like living lies and the foreclosure fraud site and all of these, Facebook pages and sites that people come up with. What can you say about them?
Well, to begin with, you can hear me okay, right?
Mm-hmm.
Oh, good. To begin with, if we just take a look at one of the worst attorneys that I can think of, Neil Garfield, and look at what has happened with him. I couldn't believe that he made the kind of arguments that he actually made and then stuck his chest out, figuratively speaking, and challenged anybody to come up and give him a hard time or disprove it. Like, who are you to disagree with me? You're not a lawyer. You don't know anything. The fact is, Neil Garfield has made arguments about the Truth in Lending Act, such as to suggest that a person should file a notice of rescission even if he got a purchase money loan and even if it was more than 3 years since closing. Now, the Truth in Lending Act make it clear that you can't file a notice of rescission later than 3 years after closing. And when you do file it, the court gets to make a determination as to whether or not the rescission has to take place if the creditor doesn't agree with it. For example, the borrower, to begin with, the law says that you cannot get TILA rescission rights on a purchase money loan. If you borrow money to buy the house and don't already own it, then you're not protecting your family home. The Truth in Lending Act has nothing to protect as a family home there. So therefore it doesn't apply. The right of rescission past the 3 days limit doesn't apply to circumstances like purchase money loans. You have to be putting your family home at risk in order to have the right to rescind the loan under the Truth in Lending Act. But Neil Garfield was telling people to buy his $3,000 TILA rescission package, which included his opinion as to the viability of a TILA rescission claim. It was just completely absurd, and of course it was a ruse intended to get people to pay him money for a useless service. He might as well be selling, and he does recommend for people to purchase a securitization audit, even though securitization audits have been denounced by just about every court that's heard them because, the pooling and servicing agreement, the borrower is not a party to it, not injured by it, and not a beneficiary of it. So he really has no standing to bring it up in court. And the same with the assignment of a note and robo-signing. If you're not a party to it, you're not injured by it, you're not a beneficiary of it, you have no right to bring it up in court as a cause of action. In other words, a dispute about the assignment is between the assignor and the assignee. It has nothing to do with whether or not the borrower owes the debt. Courts have said this all across the land.
So
but Neil Garfield, yes,
he's basically selling something that isn't going to work.
Yes, and worse, he blogs about it to infect the thinking of whoever is hapless and feckless enough to actually read his blog and believe it. I mean, you go look at the Living Lies blog, and now he's got another blog to deepen the well, I suppose you'd say, and that's called Lending Lies. So I created the Living Lies the Truth blog, or you can look it up, Google it, in order to put to rest many of the questions about that Neil Garfield raises that are simply nonsense. I mean, he brings up issues that are irrelevant. He still tells people that all of the appellate courts today who don't allow a rescission, don't require a rescission to terminate the mortgage instantaneously, simply aren't appropriate. I mean, he thinks that a borrower should file a rescission letter, a rescission notice, send it to the creditor every time he has a loan, for any loan. And, of course, that's crazy. If a borrower can't tender, if he can't repay the creditor what the creditor gave him, there's going to have to be a court getting involved. But until the court gets involved, the creditor doesn't have to go along with it. And that's what the Jesenowski opinion was about in the Supreme Court. It didn't rule that if a rescission letter gets sent, the loan is terminated and the lien is terminated. I mean, it ruled that all a person has to do to initiate rescission is to send a notice within 3 days. He doesn't have to sue within 3 days. I mean, not 3 days, 3 years. So the point is just a complete absence of understanding, or at least admitting an understanding of the law, is what characterizes Neil Garfield's nonsense. Not to mention the fact that he's been disciplined by the Florida Supreme Court for numerous instances of taking people's money, not returning their calls, and refusing to give their refunds.
Well, I'm going to jump in here because we have to go to a commercial break. And you didn't catch the first part of the show, but I actually read the discipline against him. And I know Storm has some comments. But let's go to a quick commercial break. If you do want to call in and ask a question, the number is 646-668-8512. Stay with us.
Have your house payments skyrocketed under an adjustable rate mortgage? Have you been laid off or had your hours cut? Are balloon payments coming due? You need help from mortgage fraud examiners. To stop the housing crisis, Congress and the White House are pinning their hopes on homeowners renegotiating their mortgages. The trouble is, the banks are saying no 80% of the time. Mortgage fraud examiners can help you get the leverage you need to turn things around. They estimate that up to 85% of all mortgages are legally deficient. Mortgage fraud examiners can perform a mortgage transaction analysis and an appraisal to find legal deficits in your mortgage. It's like CSI for your home loan. Banks and lenders suddenly start cooperating when faced with a lawsuit for violating lending laws or appraisal fraud. Find out how mortgage fraud examiners can help you. Visit Mortgage Fraud Examiners. Call 844-920-7200. That's 844-920-7200.
We are back on the Fraudsters Radio Show. I'm Laurie Z with my co-host Storm Bradford and guest consumer advocate Bob Herr. And Storm, I could almost hear you chomping at the bit to cut in. So what did you want to respond back to with what Bob was just talking about?
Well, a couple of things, and this answers one of your questions as well, is how do you know if the arguments the attorney's making are any good or not? You read the court cases. Now, understanding that most homeowners don't have access to the types of services that we have at our litigation support company, but there are ways that they can look up cases. There's what's known as Google Scholar, and you can look up case law on Google Scholar. And you will find that all of these arguments that these stall attorneys make, produced the note, MERS, securitization, didn't get into the trusted time, robo-signing, assigning, standing, and so forth and so on, the courts, every court in the country is basically will tell you that they're nonsense, that it's the contract is what you have to attack in this instance. Now, dovetailing on what Mr. Hurt was saying is that there has been hundreds of post-Jesinoski cases. Jesinoski himself lost his home to foreclosure. Hundreds now of cases from all over the country where the courts have said all of these arguments that Neil Garfield makes is absolute nonsense, nonsensical and schizophrenic. They are just totally ridiculous. But he continues to say, oh, well, they're just trying, the Supreme Court was clear in what it said. Well, clear in his mind, but not in the mind of jurists and competent attorneys. So when hundreds of cases have been lost by homeowners making these arguments, you now know that whoever's making that, whatever attorney's making that argument has no clue, and they're incompetent for making it. Also, too, I'd like to say that Mr. Hurt, because, and I'll give you a little background on Mr. Hurt. I met Bob probably 5 or 6 years ago, and he was a owner of a computer company that sold hardware actually around the world. And when he retired, he had a interest in law and an interest in social subjects and so forth. So at the time, he was looking at foreclosures and wanted to know what would work and what didn't work. And he contacted us at Mortgage Fraud Examiners, and I explained to him what we know, what works and what doesn't work. And he said, well, I'm going to look into it. And after a couple of months, he got back and he said, everything that you said is absolutely factual. All of these other things, these securitization audits, chain of title audits, forensic loan audits, they're all scams. People making these ridiculous arguments, they're all scams. And it's clear that attacking the contract is the only thing that works. Now, because Mr. Hurt started publicizing on blogs and so forth and so on that what Mortgage Fraud Examiners does is the only thing that works, he gets attacked by the scammers and by the stall attorneys. So much so, and this should lay it to rest today, that because Mortgage Fraud Examiners gets attacked by the scammers and the stall attorneys as well, that a lot of these people were trying to say that Bob Hurt and Storm Bradford were one and the same. Well, having Bob on the show today kind of proves that that's a lie as well.
I can vouch you're two different people since I know you both. I've met you both separately, not the same people. But the attacks are unbelievable. And so what I find is that, you know, you've heard the term sheeple. And so sheeple tend to be the ones going off in the wrong direction. Like, if 99% of people were walking off into the desert saying, hey, I see water over there, and I'd be the 1% going, no, it's a mirage, I'd be walking in the opposite direction. But most people, I think, they hear what they want to hear, and the scammers give them hope, whatever kind of scam it is, gives them hope, whether it's about keeping their house, whether it's about they want a windfall of money from the U.S. Treasury, whatever it is, or the straw man theory. There's really no money. So people want to believe it because they want to have hope. And then you have people that take that hope and ultimately crush it after they've taken all the money that the people have left. Now there's no hope when, I know you've said it could take like 3 years for a house to foreclose, so why would you even bother paying an attorney to do anything?
Well, first and foremost, the majority of these stall attorneys do not tell the homeowner that all they're going to do is stall.
Right.
So that homeowner goes in believing that this attorney is going to help them save their home, and it's just not true if they're making those types of arguments. Now, to their defense, these attorneys don't know how to analyze these mortgage transactions or appraisals, so they don't know what evidence is there to use against the bank. So,
well, excuse me, I'd like to interject something if you don't mind.
Go ahead.
I mean, just right on the point here, lawyers who are in the title business, in other words, title to real estate business, that want to handle litigation, people come to them asking them for help. The lawyer does not know, as Mr. Bradford said, how to analyze a loan, but he understands the principles of breach of contract, which is what the person has been accused of doing, the borrower, and he knows that there are various ways to deal with breach of contract to get the court to dismiss the case, if for a variety of reasons, such as failure to state a claim for which the court can grant relief. And the point here is that when borrowers are deluging lawyers with requests to help them, the lawyers almost simply can't resist taking the case. And they are thinking to themselves, well, I know that I can't get my client any money, but maybe I can stave off or delay the foreclosure for a while to help them get their affairs in order or something. So what Mr. Bradford calls them stall attorneys, they might not have started off to be the stall attorney, but they know two facts that are pesky. Number one, the borrower doesn't have much money. If he did, he'd be making his mortgage payments. And number two, in order to mount a proper defense, which would be an attack, he is going to have to spend maybe thousands of dollars, such as by purchasing a mortgage examination service. And how long does it take you to do a mortgage examination? How about you and your team of experts, Mr. Bradford? How long does it take?
It's usually
to examine the mortgage.
7 to 10 business days to examine the whole transaction. We examine the whole transaction.
So you've got to spend 50 to 60 hours going over a loan transaction, all the things that happened in that loan from day zero to present time. You have to go through all of that stuff, and that takes 50 hours of expertise that most lawyers simply do not have. So they have no choice but to tell the client, sorry, I can't help you, or help them with what they can. Sorry, they can't give you the full service that you need. So what ends up happening is Neil Garfield actively promoted this as a business method, knowing that there are bar rules that prohibit what's called, that mandate expediting the litigation rather than dragging the feet on it. And all this turns out to be is another way of dragging feet. In other words, delaying the inevitable loss of the house. The only way that a borrower can get the help that he needs from attorneys is to go to the attorney with the proof in hand that the appraiser, the mortgage broker, the lender, the creditor, the servicer, or the title company, or somebody involved in that loan hurt him. In other words, he's being accused of breaching the contract. He's got to go into the court and prove that somebody injured him in the process. That's the only way he can get damages. And, of course, if he comes to the court with that kind of proof, the judge is going to rule in his favor, and all the creditors know this. They're not going to let this happen. They're going to give a settlement. They're going to, offer a settlement to the borrower to keep the thing out of court. There are a few stellar cases where the creditor's lawyer was such an idiot that he bucked against this. But in cases like that, the lawyer usually gets fired and the creditor ends up having to pay a whole lot of money damages. That's what happened in the Brown versus Quicken Loans case.
Bob, I want to jump in here. So if Neil Garfield is writing and selling the system that doesn't work, would that constitute fraud? Because does he? If he actually believes it works, then maybe it isn't. But if he knows it doesn't work and he's selling it, isn't that a deceptive practice?
Well, he's selling the service where he's saying, I'm going to look into it and give you my opinion about it. I guess that's not fraud, but since he knows the basis of his opinion is nonsense, he should know he's defrauding the client.
Okay, and Storm had a comment.
More importantly, the ethics counsel will tell you that an attorney that's trying to stall litigation is an ethics violation, and attorneys, because a foreclosure is a breach of contract case, the bank is alleging the homeowner breached it. Any attorney that is not examining that mortgage contract to see if there's anything to be used against the bank, that's malpractice. So either way, there's a problem with what they're doing. And as far as fraud is concerned, how can someone like Neil Garfield or anybody else that's making these arguments that go into court and lose every single time, how can they not know that what they're doing is BS? And then
wait a minute. Are you saying that Neil Garfield never won any of these cases over, that he's doing in behalf of borrowers?
Well, I've asked him, other attorneys around the country have asked him to produce. He said he's won hundreds of cases. I asked him like others have asked him. You don't need to send us hundreds. You don't need to send us 10. Show us one case where you've ever represented a homeowner that won. He can't do it because they don't exist. Now,
well, what in your estimation constitutes a win? Isn't it a win to get the case dismissed?
No, we talked about that earlier. They can come back. They can come back. But I want you guys to hang on. We got to do one commercial break. Hang on. I want to come back with this topic because it's hot. So stay with us.
Have your house payments skyrocketed under an adjustable rate mortgage? Have you been laid off or had your hours cut? Are balloon payments coming due? You need help from mortgage fraud examiners. To stop the housing crisis, Congress and the White House are pinning their hopes on homeowners renegotiating their mortgages. The trouble is, the banks are saying no 80% of the time. Mortgage fraud examiners can help you get the leverage you need to turn things around. They estimate that up to 85% of all mortgages are legally deficient. Mortgage fraud examiners can perform a mortgage transaction analysis and an appraisal to find legal deficits in your mortgage. It's like CSI for your home loan. Banks and lenders suddenly start cooperating when faced with a lawsuit for violating lending laws or appraisal fraud. Find out how mortgage fraud examiners can help you. Visit Mortgage Fraud Examiners. Call 844-920-7200. That's 844-920-7200.
Welcome back to Fraudsters Radio Show. I'm Laurie V. here with Storm Bradford, owner of Mortgage Fraud Examiners, and consumer advocate Bob Hurt. And we've been talking about Neil Garfield. One of the things I wanted to mention was he apparently has his own radio show. So I'm thinking maybe we should invite him to be on this show to address some of the things that we're talking about.
Well, like I said last week, Laurie, I've got a standing invitation to any stall attorney, any scammer out there that's providing these scam audits to come on the show. It's a standing invitation. I'd be more than happy to hear from them. But to answer Mr. Hurt's question about a win, a bank comes in to foreclose, as we spoke last week and again at the beginning of the show, and they didn't have the note when they filed the lawsuit. In Florida especially, it's not so much in other states, but especially in Florida, the court's going to send them packing. Now, technically, is that a win? Well, that not in the eyes of the homeowner, because the bank comes back and refiles the lawsuit, and then they have no argument, and they take the homeowners home. Now, in the homeowner's eyes, was that a win or was that a loss? Anytime the house goes away and the bank takes the house, that's a loss to the homeowner. Mm-hmm. So that's what we talk about, wins versus losses. A win is when a homeowner keeps their home and or gets financial remuneration and or free title to the property. That's a win. Oh. Stalling is not a win.
So what happens if somebody, purchases the mortgage exam, and let's just say it shows, that the bank breached first, whatever issue there is, and, you look at everything and you go, okay, this person has a chance. But then they come to a state like Florida and they can't find an attorney. Is there a way to do it themselves? Like, what do you do with people that just can't find an attorney that wants to use the information? Because you're saying that basically it's malpractice for an attorney not to, but now here's proof and they still don't want to do anything. What does the homeowner do?
Well, in every one of these contracts, there's a clause that says that if the borrower finds anything wrong with this transaction, they have to give the bank an opportunity to take, quote, corrective action. Well, the only corrective action they could take is to compensate the homeowner because the damage has already been done. That same clause in the contract calls for the homeowner to send to the bank, which is defined as a grievance letter, to the bank outlining the deficiencies in that contract, the problem areas of that contract. And that goes off to the bank. In a judicial state, it goes off to the bank's attorneys. We also give homeowners all the state and federal entities to CC a copy to. In non-judicial states, it goes off to the bank, it goes off to the trustee, and again to all the state and federal entities. So that's what they could do themselves for free. As far as attorneys are concerned, our recommendation to anyone that seeks any type of legal help is personally, knowing what we know, I wouldn't go to anyone that held themselves out as a foreclosure defense attorney. I would find either someone that's a contract attorney or a personal injury attorney. Now, why a personal injury attorney? Personal injury attorneys are used to dealing with large corporations, i.e. insurance companies. So they can help you negotiate something. But what you need in order to be successful is evidence of any type of wrongdoing within that transaction to use against the other side. Now, who's the other side? Depending upon the factual scenario of the case, it could be the person who sold you the home, could be the real estate agent, could be the mortgage broker, could be the title company, the bank, the appraiser. It could be your own attorney has screwed your case up, or any and sundry group or individuals that could have exposure to you. You don't care. Your outcome is to overcome your breach of that contract. And in order to do that, you're going to have some sort of evidence to use against the other side, and that's what this transaction analysis provides to the homeowner.
Right. Well, I know when you do the exam, you also tell people that save every single document they get, whether it's a loan modification document or a debt collection type document, because you actually look at all of those documents in addition, correct?
Well, let me tell you, that's why it takes 7 to 10 business days to do, because what we tell homeowners is if you have anything that dealt with that last transaction, we want it. More specifically, that means all of your closing documents, your appraisal, any correspondence to include emails, any notices of default, substitutions trustee, loan modification attempts, forbearance attempts, short sale attempts, any nonsense you may have bought from one of these scammers will help you get your money back, show you how to get your money back, any court cases filed, any bankruptcy. Again, we need everything. On average, we probably get 1,000 pages of documents from homeowners. We've had as many as 5,000 pages to examine for a homeowner. So, but we tell homeowners, the more you have, the more we like it, because the more that you give us, the more of an opportunity that we have to identify something to help you overcome your breach.
Now, I have a question for you. So if the borrower is looking at it and saying, I don't have enough money for that mortgage exam, but I know these guys, they forced me to take insurance, even though I already had insurance on the price, hazard insurance. And the insurance they forced me to take was like 3 times as expensive. Isn't that good enough? Can't I just go to court with that? I mean, do I have to bring in a bunch of other things? Why can't I just go into court with that and expect that to work?
Well, for the very simple reason, most pro se litigants don't know what the rules are, don't know how to maneuver themselves in the court. And if you have any competent attorney that's working for the bank, the facts can be on your side and the law can be on your side, but that smart attorney will beat you procedurally. So you'll end up losing based on that. What they can do is that they can call the insurance commission and see if they'll help them. There's other government agencies they call, to elicit some help. But, if they don't have the money to do an exam, unfortunately, I have people all the time that call up and they say, well, I don't have any money. Well, excuse me, you have a $2,000 a month mortgage payment that you haven't paid in 4 years. How come you don't have any money? So
right.
If they don't have money, they need to find some money, because at the end of the day, they're going to lose their home. So, but if there's no way, they have no relatives, they have no way of coming up with any money, the recommendation is do a deed in lieu of foreclosure and just get on with your life. Now, you will lose your home, but with the deed in lieu of foreclosure, there's several government agencies that will guarantee you financing after 3 years. And if there's extenuating circumstances, it can be less than that with a 580 credit rating. And in most instances, these banks will give you some money to move. I've seen Bank of America and Chase give a homeowner as much as $30,000, because in judicial states it costs approximately $70,000 to foreclose on a home. So,
well, what about in the case where a person has found out something, the borrower, that, like, for example, he got placed insurance put on him, which is real obvious. Can't he just bring up that in a lawsuit and then wait till later to bring up other things he could find?
Well, and we got about,
like, say, appraisal fraud or something?
We got about 1 minute, guys.
They can do anything, but at the end of the day, there's lots of instances where the bank placed insurance on the home, which the homeowner agreed they could do. So what are the circumstances of them placing that other insurance on it? Was the homeowner providing the insurance, the hazard insurance? Were they providing the flood insurance? Were they paying for that? What they can do is just go back to the bank and say, hey, wait a minute. Here is the canceled checks of the insurance that I paid. Now, who do I get my money back from? Do I get it from you or do I get it from them? Well, if the money is escrowed, the bank paid it. You can go to the insurance company and say, hey, look, you got paid twice for this. I need some money back. So,
right.
But any situation, you got to know the particulars of it before you can comment.
Great. Well, I want to thank both of you guys. Bob, thanks for being a guest on the show. Storm, thanks for co-hosting, because we're going to have some great shows coming up also with some special guests. So thank you for joining us today on Fraudsters Radio. Please join us again next Monday from 1 to 2 p.m. Eastern Time live. And remember, we do want to hear your stories. You can contact us through the Fraudsters Radio Facebook page.
Bye, Laurie.
Bye-bye, guys.
Bye-bye.
Bye.
Have your house payments skyrocketed under an adjustable rate mortgage? Have you been laid off or had your hours cut? Are balloon payments coming due? You need help from mortgage fraud examiners. To stop the housing crisis, Congress and the White House are pinning their hopes on homeowners renegotiating their mortgages. The trouble is, the banks are saying no 80% of the time. Mortgage fraud examiners can help you get the leverage you need to turn things around. They estimate that up to 85% of all mortgages are legally deficient. Mortgage fraud examiners can perform a mortgage transaction analysis and an appraisal to find legal deficits in your mortgage. It's like CSI for your home loan. Banks and lenders suddenly start cooperating when faced with a lawsuit for violating lending laws or appraisal fraud. Find out how mortgage fraud examiners can help you. Visit Mortgage Fraud Examiners. Call 844-920-7200. That's 844-920-7200.